Good morning. My name is Starla Leverett, and I'm General Counsel of the Alabama Real Estate Commission. And welcome to Briefly Legal. I'm excited to have some guests with me today.
I'm Ryan Adair, and I'm the Education Director at the Commission.
I'm Serena Cronier. I'm one of the attorneys for the Commission.
And as always with Briefly Legal, I want this to be as interactive as possible. So if you have a question during our presentation, please just raise your hand on your computer icon hand, and we will call on you. You can unmute your mic, ask your question, and just remember to please mute it back after you're finished. So today's Briefly Legal is actually going to be in two parts. The first part is going to focus on some upcoming legislation, and the second part is going to focus on how a complaint is processed here at the Real Estate Commission. So let's kick it off with part one. We are very excited about legislation that's going to be proposed during the 2024 legislative session. This legislation directly affects and benefits both licensees and consumers. This legislation is a culmination of years of task force work and licensee input and how the real estate industry can be improved and modernized. This morning, we're going to present an overview of this legislation, but because it is quite a lot in the legislation, it's not going to touch on everything. Therefore, the best thing to do is, after this meeting, is to just unpack it, dig into it yourself. And you can do that. You can find the legislation on our website. You can also find a synopsis of that legislation on our website. And that's going to be at arec.alabama.gov. So let's start talking about what's in this package. The very first part, the definition section, because that's the first part of license law, you're going to see some new definitions. Some of the words that we've put in there and defined are apartments, equitable interest, listing agreement, team, and owners. I want to focus on the word owners because the definition of owner that's proposed in this legislation is a person or entity legally deeded real property. Why is this important? It's important because this definition will prevent the marketing or listing only of equitable interest in property, known as wholesaling. You must now have a real estate license in order to do that. This is because in the past, some people relied on the ownership exception. They said, I have an equitable interest, therefore I'm an owner, therefore I can sell this without having a license. This takes that ability to find themselves in that loophole out. And so everyone was now going to be on a level playing field, and anyone that is selling an equitable interest or wholesaling a property will have to have a license. So we're excited about that provision. The next thing I'm going to discuss are co-brokerage agreements. Currently in our law, out-of-state brokers can co-broker, collaborate with in-state brokers on certain real estate transactions. Most of these actually involve commercial transactions. But currently in the law, there's no limit onto how many transactions per year they can collaborate on. This bill would limit that to three transactions a year. But please remember that a portfolio, meaning it's more than one transaction within a single transaction, it's multiple properties, that will only count as one transaction. So it's going to be 3 transactions a year and or up to 50 million a year in transactions. If they exceed that, then they would have to get an Alabama license if they're going to transact more than that in Alabama, in the state of Alabama. I'm going to turn it over to Ryan now to talk about some of the educational provisions.
Thanks, Darla. I'd like to start with the licensing of education approvals. For example, instructors, administrators, and schools. We're looking at a few changes with the renewal here, and actually with the approval as well. What we're going to do, first of all, is change some of these approvals to actual licensing. If you look in license law now, you'll see that both administrators and schools or approved schools, there's no fee for approval. So looking at basically with the administrators and the CE only schools, not the licensed schools that offer pre-license, but the CE only schools. Both of those right now pay no fee for approval or renewal. But I mean, both have a big responsibility as far as maintaining school records, planning courses, entering course credit, and all of that. So we feel it's fair to require approval fees and renewal fees for both the administrators and the CE only schools. When you look at renewal for all administrators, schools, and instructors, this is going to be changed to kind of resemble more of the renewal that you're familiar with as salespersons and brokers and companies. Right now, as far as late renewal in education, there is no late renewal fee. The deadline is the end of October of every odd year. If someone doesn't renew prior to that deadline and they renew in October or November, there's no late fee. So we're going to equate this with the license renewal for all licensees and have a late fee associated with that. Also, the late renewal deadline. Right now, that's December 31st of the renewal year. So education renewals, if late, only have 3 months past the deadline to renew late before anything not renewed would basically lapse. Once again, we want to equate this with the license renewal in the even years and give a full year after the deadline for instructors and schools to renew late. Of course, just like, I'll say this a lot, just like with the normal license renewal that you as licensees are familiar with, anytime you go inactive, you have to pay a license activation fee to activate again. Right now in law, there is no activation fee for instructors or schools. So we're going to have an activation fee that will be required at any time an instructor or an administrator has to activate a license. And of course, just like with the CE credit that you're familiar with pre-licensed instructors, if they are inactive and they need to activate that license, they will not be able to do it until they have their 12 hours of instructor CE completed. And that's what will allow them to then pay the license activation fee and activate that license. Now, still in the education area, let's look at the certification of distance education courses. Some of you may not be familiar with how that's taught, but you have probably taken some online courses yourself when completing your CE requirement. One change that we're looking at making is to allow us to certify synchronous distance education courses. Right now, any kind of distance education course is certified through ARELO. That's the Association of Real Estate License Law Officials. They take care of distance education certification for synchronous courses and asynchronous courses. And let me make sure everyone is familiar with what I'm referring to. An asynchronous distance education course is one that's offered live, where you may have the students taking the course at their homes, you may have the instructor in a different location. People are all spread out taking that live course. They're in different places. So that's distance education, but they're taking it at the same time, live instruction. So that's synchronous distance education. Asynchronous distance education is what most people are familiar with, and that's when you buy a course yourself and you spend time on your own at your house or whatever, completing that course by yourself. So what we're looking at doing is, we are in this legislation, what's proposed is the commission can take care of asynchronous, we can take care of synchronous distance education courses. So that would not have to be certified through ARELO. We would take care of the certification ourselves, which is looking at the design and the delivery of that offering, and then also approve it like we do now. So basically what we're looking at is there'll be a fee associated with that. Anything that takes time here at the commission to complete, we have to charge for that. So there will be a synchronous distance education certification fee in addition to the normal fee that we charge when approving a course. Once again, this is all going to take place if this legislation passes. I'm not saying this is going to start next year. If this legislation passes, then we're looking at making the plans to start doing this at the appropriate time, which could be around 2027, as stated in the law. So what I've shared with you is some new licenses and how we're going to charge for some distance education courses. Any questions regarding these two topics that I can answer for you? Okay, no questions. Then I'd like to turn over to Serena to talk about the duration of listing agreements.
Okay. Quick question.
Yes, ma'am.
I will begin discussing duration of listing agreements, and then I'll go into teams. I know everyone's real interested in teams. Under existing license law, there's no limit to the duration of a listing agreement. This bill would limit the duration of a residential listing agreement to 1 year and prohibits licensees from recording a listing agreement with a probate court to encumber the property that is subject of that listing agreement. This brings these issues under the jurisdiction of the commission to better protect consumers. Next, teams. I know everyone's excited about teams. So under existing law, real estate teams are not recognized, licensed, or otherwise regulated. This bill defines and licenses real estate teams and allows for the regulation. Teams are defined as licensees within the same company that group together to share consumers, resources, knowledge, and or commission.
I see that we have a question.
Okay.
And I believe that is Larry. If you will unmute your mic and ask your question.
Yeah, my question was for Ryan.
Okay,
you hear me?
we'll jump back to that. Yes, sir.
Yes, on the distance education, you're going to certify the instructors too?
Well, we always, the requirements for an instructor will not change. That will still be, as in our law right now, the CDEI, the Certified Distance Education Instructor designation has to be acquired. But yes, we will always approve the instructors. The only thing that would be changing would be the certification of the synchronous distance education courses.
Thank you.
Yes, sir.
All right, you want to jump back into teams?
I'd love to. So, brief history about this. Within the last decade, the formation of real estate teams has become a leading trend. While teams have enhanced the real estate industry in some capacities, the Commission has received an increasing number of complaints about teams' advertising practices. Specifically, some teams have advertised in a manner that would mislead a consumer to believe the team was actually a licensed company. By licensing teams, the Commission can formalize their formation and provide oversight to protect both consumers and licensees. Next, Starla, do you want to talk about some bad checks?
I do, because this is my favorite part of the legislation. Part of the violation section, as you probably all know, involves when you have to present to the Commission a payment for a fine or fee, and for some reason that check or the way you do it online is returned as unpaid. This bill is actually going to remove that from the violation section. Instead, what happens is if someone submits a payment for a fine or a fee, your real estate renewal fee, let's say, and it comes back as either insufficient funds or unable to locate account, then if that payment is not actually made whole to the Commission within 30 days, then your license is going to become inactive. So basically, let's say you're going on in Alabama Interactive and you're typing in your information, you accidentally type in a wrong number in the account, and then it comes back to us unable to locate that account. The Commission will notify you, and as long as you make that whole within 30 days, then your license would not go inactive. If you do not, then it will go inactive. And then if it moves to 60 days of not repaying us the funds, because basically you have something that you didn't really pay for at that point, then we would actually lapse your license if the payment is not made, I'm sorry, not 60 days, within 6 months. So I think this is going to cure that. Historically, I think there's been a lot of licensees who obviously were not intending upon violating any type of license law, but it ended up that you typed in a wrong number or you didn't realize that account had been closed, different things like that. So this is going to move it out of the violation section and allow us just to deal with it, I think, in a much more efficient manner. So it is my favorite part of the bill because I think it's going to help us expedite things at our hearings. The next part of the bill I want to talk about are tracking of escrow trust funds. And the reason this is important or has become important is because it seems like in the past few years, a lot of brokerages have moved from actually holding money. They don't want to touch it. I get it. It's like the hot potato. You want to pass it to somebody else. You don't want to have to deal with trust accounts and all that. So now a lot of closing attorneys are holding the money and a lot of title companies are holding the earnest money. What's happened in that is we're kind of losing the earnest money. So this will actually now be part of the violation section. It'll be a new violation that it requires licensees that are acting as the buyer's agent to notify the listing agent in writing within 3 business days if the buyer, their buyer, has not deposited the earnest money in accordance with the contract. So you have to follow up and make sure that your buyer actually gave that money to the closing attorney, and if not, you have to notify the listing agent that it's not there. It additionally requires the listing agent to notify his or her client if the funds have not been provided to the listing agent within 3 business days of the time specified. That way, both parts, the buyer's agent is notified, the seller knows, hey, the money's not there. This became a huge issue when the market was really hot, a lot of offers being made, a lot of earnest money changing hands. We had a lot of consumer complaints when those deals would fall apart, and no one had followed up to say that the buyer never actually took the money to the closing attorney's office. So there was no money to fall, there's no earnest money there to help the seller in those circumstances. So this will be a new violation, and I think it'll just be a better way to keep track to know, okay, the earnest money that's there for a reason actually made it to where it was supposed to be. And I think now Ryan is going to talk about a big part of the law.
Well, first, let's open the floor. Any kind of questions regarding what has just been shared, the listing agreements, teams, bad checks, trust funds? Any questions regarding those?
All right, Mr. Larry, go ahead and unmute again.
Yeah, this is a question for Starla, please. On the trust funds, that you said business days, does that exclude state and federal holidays?
No, it does not. We're not looking at it in the legal term of the word, but remember also that it's also in accordance with the contract. So if the contract said for some reason they had 2 weeks, to get it there, obviously it doesn't start until those 2 weeks are, run out. So you're going to look at the term in your contract. So it's not always going to be a straight 3 days. It's going to be whatever however long the contract has for them to deliver it. And then we're going to do the 3 business days, and Mr. Larry, that might be something that we need to further define in rules, because remember, this is just the legislative part. And as what happens is, as we, hopefully when this becomes law, we're going to realize, hey, we need to fill in something to make sure everyone understands. And maybe we do that by rule, and what you just suggested, which is a great suggestion, or even in the bill itself, is we need to make sure everyone understands this is 3 business days exclusive of holidays, federal holidays, things like that, and or it's just 3 days no matter what. So thank you for that input. I'm going to write a note on that.
Yeah,
Thank
state
you.
and federal holidays.
I got it. State and federal. I'm going to borrow Ryan's pen right now.
Thank you.
All right, we have another question from Ms. Beverly.
Yes, on the team's information, you said it would be a company team that would be licensed. If the team members are under, say, 3 different brokers because it's 3 different branches, how are y'all going to deal with that?
I believe our intent is that they would all be under the same qualifying broker.
Okay.
And if we haven't defined that correctly, I'm going to write that down too, because this is what we're here for. We're here to have this interaction to make sure we cover, because the one thing I don't ever want anyone to think is that we're not practicing licensees. So we don't know what, sometimes we don't know what reality is when y'all are out there every day doing this. So that's why input is so important from y'all that do it every day. But what our understanding is that most teams operate under the same qualifying broker. So I'm writing a note about that as well, Ms. Beverly.
Okay, yeah, I've had one team that had 3 different QBs in 3 different associations, but they were branches of the same company.
Gotcha. Okay. Thank you.
Mm-hmm.
And we have another question from Holly. Holly? Please unmute your mic. Okay. While we're waiting on Holly to do that, do we have any other questions right now?
Yes. This is W.A. Casey. On the verification of the earnest money being deposited in the account,
Yes, sir.
How will it be handled again? If the agent, I call him?
So the agent would just follow up with the attorney's office. I think maybe the cleanest way to do it, so you always want something in writing, obviously, is to just, if it was me, I would send an email to the closing attorney if that's where the money was supposed to be. Dear closing attorney, I just want to confirm that my client deposited the money according to the contract. He writes back, yes, they have. That's all you need. That's confirmation. You've done your part. And then if for some reason he writes back and says, no, they have not, and the time has expired, simply you could forward that to the seller's agent, the listing agent, to the listing agent, so that you can let them know, as required by the law, I'm informing you under license law that my client has not deposited the funds. And then they have a duty at that point to tell their client, the seller of the home, just letting you know the earnest money's not there. So I think an email is just the best way to do it, to make sure you have it in writing.
Will a copy of that email have to be in the file?
For auditing purposes, that is another thing that we're going to have to look at probably in rule. But I would think that the importance of it being in the file is if the earnest money actually didn't show up. But I would always put a copy of it in my file.
Thank you.
You're welcome. All right,
Okay,
back
I'm
to Holly.
unmuted now. I'm sorry.
It's okay.
Okay, so going back to teams, will they be treated like branches are currently treated? For example, the Tim Baker team brokered by EXP. Yes.
So it's not going to be treated as a branch. Well, Holly, let me kind of break this down. It's not a branch office in the sense that they get to have their own location.
No brick and mortar required.
Exactly. Yeah.
Okay.
Because that would then be a branch office, which we still
Right.
have, and we're not changing that in the law right now. So no, they would not have their own branch office. They could, again, have a workspace as long as they're not advertising that address or meeting clients there. Of course, teams can have their own workspace where they can go make phone calls, they can work on their computer, they can meet amongst themselves to discuss deals they have going on. But no, this would not alleviate them or give them some way to have a branch office on their own. No, ma'am.
Okay, but in advertising and marketing their team, they would need to have their team name brokered by.
Well, they don't have to have the words brokered by. The only thing we require is that they would have their ABC real estate company on the advertising as well. They still have to have their brokerage and their team name. And we're going to talk a little bit more about some advertising new parts that'll kind of clarify that, Holly, in a little bit.
Good deal. Thank you so much.
You're welcome.
Okay, let's move into the next topic that I'm going to share with you. And this, some of you may have not really followed what I was talking about before as far as the licensing of administrators and schools and all that, but this is going to affect pretty much everyone. We're looking at the requirements for salesperson and broker licenses and some changes to that. As you know, right now, the first step is to take a 60-hour salesperson pre-license course. No change to that at all is being proposed. After that, step 2 is to pass the license exam. No change to that at all. The changes come in after someone passes that license examination. Right now, the next step would be you get a temporary salesperson license and you start working and then have to complete a post-license course within a certain period of time after that. What we're changing now is removing that post-license course. You'll have pre-license course number 1, pass the license examination. After that is passed, then someone has to take another pre-license course number 2, which is going to teach that individual how to use a license before the license is issued, instead of giving someone a license with them not knowing what to do with it and trying to learn as they go. That third step will be a mandatory pre-license course after the license examination. After that course is completed, that is when an individual can actually have a temporary salesperson license issued and be licensed with a company. After that, then they will have basically 15 hours of training, because what we're looking at is a 60-hour pre-license 1 course, a 45-hour pre-license 2 course. And then when the temporary license is issued, then there'll be 15 hours of training that this new licensee will get with a company. So it's not in a classroom, but it's training at the company with that qualifying broker being responsible for what has taken place. And what we're proposing in the legislation is that new licensee will choose the area of real estate in which he or she is interested. It could be residential, it could be commercial, it could be property management. That individual will say, for example, I want to be in commercial real estate. So I get licensed with this commercial real estate company, get that 15 hours of training on the job that's overseen by the qualifying broker of that company. And by the way, that qualifying broker will be responsible for what we call a core competencies checklist, which will be provided for each area of real estate, depending on what type of company it is. That qualifying broker will make sure that that new licensee is learning these items that are required for that area of real estate, checking those off. At the end of that training and learning everything, that's when the qualifying broker will sign off on that core competencies checklist and send that into us. And when all that is completed, that is when the temporary salesperson will be able to apply for the permanent salesperson license. So we're trying to put more education in line in the licensing process before someone can be active with a real estate license.
Ryan, I have a quick question about that.
Sure.
Let's say that I think I want to go into residential sales. So I take the residential portion of it And then 6 months into my career, I said, this is not for me. I want commercial. Do I have to go back and retake commercial?
The answer to that is no.
Okay, good.
If someone, because we know that can happen.
Yes.
Someone may be excited about commercial real estate to begin with. They start practicing that after getting the permanent license and say, you know what, this isn't for me. I think I want to go to this company over here and get into residential. They can do that, but all you have to do is complete that initial training. You don't have to complete that training every time you change areas of real estate,
Perfect.
basically.
Okay, thank you.
All right, so now what we're looking at is that new licensing process there for initial licensees, for someone who's getting licensed as a temporary salesperson and then as a salesperson. We're also looking at changes for those who want to be brokers. Right now, the law states that in order to become either an associate broker or a qualifying broker, you have to be active 24 of the previous 36 months before you can get that type of license. What we're looking at in this legislation, kind of keeping that the same, where you still have a salesperson has to be active for 24 of the previous 36 months, but that salesperson cannot immediately get a qualifying broker license and open their own company. They can first become an associate broker. That's going to be a requirement to be an associate broker first. And then as that associate broker, once again, be actively licensed 24 of the previous 36 months before qualifying to become a qualifying broker or being able to become a qualifying broker. So we're looking at making sure that with each level of licensure, someone has the experience that's needed to qualify for the next step. And also, before someone can be a qualifying broker, they will have to come to a training here at the commission specifically for qualifying brokers. We can't just say, okay, you've been licensed for this period of time, here's your qualifying broker's license. There are real specific things that we have in a rule that was approved not too long ago, specific requirements for qualifying brokers, what their responsibilities are. And we want to make sure that anyone who's becoming a qualifying broker is aware of those requirements and what their responsibilities are. So what we're looking at is more time of education to be a salesperson. We're looking at a qualifying broker signing off on a new salesperson. And if that person wants to be a broker, we're looking at a specific period of time as an associate broker before meeting the necessary requirements to be a qualifying broker. Any question? Well, and let me share this with you before I ask for questions. Please understand that this is not something that we just decided here in the office. We didn't have a little discussion and make this up and say this is what way we think it needs to be. We actually had task forces work with us. These are practicing licensees, brokers and salespersons from different areas of real estate. So we had this task force work with us and make recommendations on what they say needs to be done based on their experiences. So this is a group effort with the commission and practicing licensees to recommend these changes to the licensing process. Any questions regarding what I just shared with you? Let me mention one more thing. Oh, do you have a question?
A comment, really.
Okay.
As a qualifying broker, I have a lot of agents under me. My concern is signing off on a new agent saying that I approve him, they've gone through everything and I approve it, and then the next week he does or she does something to violate a law. Are you coming back on the qualifying broker because we signed off on them to say they're ready to go?
Well, to a certain extent, yes, because a qualifying broker is responsible for all licensees in the company. Now, we're not going to say just because this mistake was made, we're going to bring you down as a qualifying broker. It all depends on, in the legal division, we'll look at the details of what happened, and they make the decision on who needs to be charged with what. So we're not saying that you'll be punished immediately every time one of your licensees makes a mistake. It all depends on what happened.
Because that makes me want to say, somebody else want my job?
It's a big responsibility.
Yeah, and we will look at it definitely in depth. We know there's nothing that's presented that is an automatic, except for the bad checks were, as an automatic yes or no. This is something that, it obviously they've done great up to this point. You can't control all future behavior. So it will not just be, no. So we'll definitely just dive into it if we get one of those in, Holly.
Okay. I think having a good mentor program is going to be essential.
Absolutely.
Well, and just let you know, depending on the size of your company, there could be like a large company that has a training division. I'm not saying this law doesn't mean that you, as the qualifying broker, has to teach that new licensee everything. You're
Right.
responsible for what happens in that company. And if you have your own training division, you can send them through that training, but you sign off at the end signifying, yes, this person has been trained appropriately.
I don't think it's a bad idea. I think it's a good idea, but, you know, the bigger your company is, the more you're going to have to be aware of who you're bringing into your company.
Exactly.
Yes.
And that is what a qualifying broker is responsible for. Yes, ma'am.
Yes.
Another question.
Ryan,
Willie, yes, sir.
backing up on it, get back to the residential and the commercial training.
Yes.
I hear a little devious in there. Is you saying that agents got to have to determine whether it's going to be a commercial broker or a residential broker? They can't do both anymore?
Oh, no, they can do whatever they want to do. We're just saying that when this new licensee comes into the company, that licensee needs to know what area of real estate they are going to be in and receive the proper training. If you have someone coming to your company who wants to be involved in property management and residential, it's going to be up to the qualifying broker to make sure that person is accurately trained. Now, we may have to make some kind of change in that core competencies checklist instead of having one specifically for residential and requiring, but let me tell you this, Mr. Case, some of these documents, the core competencies checklist, have a lot of the same items in them. They're not completely different based on the area of real estate. So that's something we'll have to make sure that we look at again to say if someone does want to be in multiple areas of real estate with a company, how that needs to be approached. Did that answer your question?
Well, yeah, answer. Well, as you've been around a long time, like myself, but we've been itching toward that all the time. I've been against it all the time. Of limiting an agent from a commercial to residential because it's
All right, I think, and make sure you all raise your hand icon. It just makes it easier to figure out who has questions. Miss Martha?
Yes, ma'am. I think I understood that the change for existing licensees to become associate brokers or qualifying brokers is that they have to complete a time period to be as an associate broker first.
Correct.
And what is, I may have missed, what's that length of time?
It's 24 being active, 24 of the previous 36 months. Just like the time that you need to serve as an active salesperson before being an associate broker, you need to serve that time as an associate broker before becoming a qualifying broker.
Okay. And then when will these changes go into effect?
It all depends on the legislation. I think that would be another section that would be in effect in October of 2026, I believe, if the legislation passes.
Yeah, because it depends on when they go into effect, kind of depends on how much we have to do on our side to get everything ready. A lot of this is heavy on IT, getting them prepared to be able to launch some things. So basically everything in the bill. And if you look at the synopsis, it will have the date of each part of the bill. So you can kind of follow that. It's going to range from October of 2024 all the way to, I think, October of 2027. Mm-hmm. So look at the synopsis. And then if you look to the right, it'll have this part becomes effective on whatever October of that year would be. So that'll be helpful.
Thank
Larry?
Yeah, kudos to you for extending that on the pre-license too, from 30 hours to 45 hours. But however, my concern is the skills and knowledge of qualifying brokers really varies. I'll just leave it at that.
Okay, thank you. Candy?
Yeah, hey, a quick question. Well, thanks y'all for being there. I really appreciate these sessions. But I have a question about the temporary sales associate licensing period. Does that time as a temporary sales associate apply toward becoming a qualifying broker or even a broker associate for that matter, or does it start when the permanent license is issued? I'm just wondering when that starts.
Yeah, good question. It starts when the temporary license is issued.
Oh, okay, great. Thank you.
Yes, ma'am. Patsy?
My question was already answered, but I do want to say that I am thrilled with the changes.
Thank you.
I've been in the business for 35 years, and what I run into today is so different from what I ran into when I was a qualifying broker with 120 agents. The qualifying brokers today, many of them don't have a clue. So thank you.
Thank you. If I can share one more thing before I turn it over to Serena, one more change we're looking at is allowing 1 clock hour CE courses. Right now, as law states, the minimum is 3 hours for a CE course. What we're looking at in this legislation is allowing 1 hour courses to be approved. However, a licensee would only be allowed to take, I believe it's 6 of those 1 hour courses in a license period. So if you wanted these 1 hour sessions, then you can take 6 of those for a total of 6 hours, but then the remaining 9 hours of your CE requirement would have to be 3 hour courses, including the mandatory courses. So that's a possible change there. And just make sure everyone understands that right now with a 3 hour course, we look at 50-minute hours. That's how it's stated in law, because breaks are needed between each hour. But with these 1 hour courses, it's not going to be a 50-minute hour. It's a 60-minute hour. It's a full 1 hour of instruction for that 1 hour course. So that's going to be in this legislation as well.
Okay, now I'm going to talk to you about advertising. I know we just had a question about it earlier, and this is a hot topic right now.
Yes.
We've done several trainings all over the state. And so especially with this new legislation, we're going to try to further define what is prominent. So our bill defines the word prominent for purpose of advertising as the use of font size that is equal to or larger in size than any other text or logo in the advertisement. And I'm going to go back to the team's question a little bit because I got where she was coming from. So if my company is ABC Realty and my team is 123 Team, you can have your team on that advertisement, but your team does not replace your company. You have to have both. And you can't put your team real big like this and your broker company real small like this. It has to be both prominent, so stand out, so you can't have a little tiny font, and your company actually has to be same size or larger than your other text. And it's because it's becoming a increasing issue where people are hiding their companies and they're advertising themselves. And so we want to make sure that the consumers aren't being led the wrong path, thinking that they're getting this one person and actually they're getting somebody else.
And Serena, this is a game changer.
Yes.
And I think that you're going to see, and I'm going to touch on this a little later in the presentation, but these are coming before the commission, these advertising cases. So this is making it, and qualifying brokers, I want you guys to know this is for you. We're making it just as simple as possible. Your brokerage, they have to make it the same size as their name, their team name. And that's it. And we're trying basically just to simplify it so there's no confusion. It's not at all subjective, which the law now, I will admit, is a bit subjective on advertising. And this is going to take that away. And I think it's hopefully going to we're not going to have advertising violations any longer. Mm-hmm. And it's going to be very clear that it just has to be the same size, and that's it. So I love it.
Yes. And that's on all your posts, your Facebook posts, your YouTube videos, everywhere that you are currently required to put it. You're still going to have to put it in the future, just equal to or larger than. And that also leads into the next topic, the fine increase. So the bill increases the maximum amount that a commissioner can fine a licensee per violation from $25,000 to $5,000. And of course, the commissioners and even us on the investigative side, we look at every case differently. We look at how many violations you have, I would say intensity of the violation, how severe, but we do look at every case differently. And if you have questions, reach out to us. We are a super friendly commission. We love to hear from you and we love to answer questions. So don't be afraid to reach out to us. By the way, I think we may have a question. Larry?
Yeah, I'm sorry. I've always got a lot of questions.
You're fine.
I think this is fantastic. Thank you so much for taking this direction. My question is, though, how does that pertain to individual logos?
It's the same. The law actually specifies that the logo has to be, this cannot be larger than the brokerage name as well.
Thank you.
Do we have another question?
Is it Beverly?
Yes, just a quick question. As far as the company name versus and the team name, whatever, some people say it's got to be at the top of the advertisement on social media. Some say below, at the bottom is fine. And there's always the chance of that see more that you have to click on as far as a one click. Do y'all have any issues with that?
I do, because I think it defeats the word prominent. If I have to click see more, that is definitely not the definition of prominent is placed in a way to attract attention. If I have to click see more, that's not placed in a way to attract attention. We're trying not to get, I mean, there's states that y'all, they have their advertising rules are intense. We're trying not to do that. So we're hoping this kind of takes care of this problem that is out of control right now. But yeah, things like that are still going to fall back on the word prominent. If I have to click, I call it the one click rule. Like, I want to just go to your spot and see it. And Maryland actually has, it's an actual rule they call the one click rule. Like, I want to go to your Facebook and I don't want to click anymore. I want to be able to see what I see right there. So yeah, the see more doesn't work. Having it as a 50th hashtag doesn't work.
Bottom of the website does
Yeah.
not work. If I have to scroll and keep scrolling my mouse down to find your company in small little letters hidden at the bottom like a copyright logo, it's not prominent.
Right, and that was my point. Some of them think that if they put it at the bottom, they're okay. Okay.
Okay, I think Holly had another question.
Yes, just a couple of questions. So we have been teaching our agents on a Facebook post, if they're talking anything about real estate, and to just assume they're advertising themselves as a realtor, that the first hashtag needs to be hashtag the company. Okay, is that still acceptable? It's the same font as the post. It's just not in the post, it's the hashtag.
Yes, it's acceptable.
Mm-hmm.
Okay, all right. The second question that I know I'm going to be hit with is all these folks that have bought ads, they've paid for signage, and EXP is not prominent. It is not as prominent as the name of their team or the name of their branch. Are they going to be grandfathered in, or are they going to have to get new signage?
Okay, we have a lot of ifs going on, but if hopefully, and if the legislation passes, we have to cross that threshold, and then we're going to look at the time period that this particular portion of the law goes into effect. And I'm going to get an answer for you that in a moment, Holly, because I don't know exactly what that is. Then yes, so the earliest it could happen is October of 2024. That this would be in effect, this portion of the law. But yes, it is going to require that. But I mean, the good news is yard signs really aren't a problem anymore. They seem to, I don't know, the ones I see around where I live, they look good. But I mean, the majority of our issues come from social media. So the good part about that is I think most of that's going to be free to change. And billboards usually look pretty good to me. Now, I want to go back to the hashtag for a moment, though. If this law does pass, that's not going to work anymore, because that hashtag is never, I just can't imagine it ever being the same size as the person's name, logo, or team name. So we would have to address that issue as well. And like I said earlier to Larry, as we get into this and things start happening, I mean, we can't predict everything that's going to come up from this legislation. So as we move forward, once we have the legislation, that then allows us that we can go to the commissioners and ask for them to pass a rule, on some specific area of advertising if we need it. This is just giving us like a starting point to jump off of. We all want to be on an equal playing field. I don't think we are right now. Some agencies, some brokerages let people slide on advertisings. Others are very strict. So when we just want to level the playing field for everyone and kind of nip this advertising issue in the bud.
Mm-hmm.
So what I'm hearing is, going forward as of today, now that we've all heard it, when we are looking at advertisements from agents, and they're asking for our approval, it better be as big or prominent as their name.
I think that that's a wise idea, even if the legislation doesn't pass, because we are focusing on that word prominent.
Yes.
Anyway, so because we have that in the law already. I will admit the word is a bit subjective, but I think that that's just a wise choice. I know when I'm looking at things, that's kind of what I'm looking at is, can I see the brokerage as quickly as I can see her name or his name? So I think that that's, even if for some reason, unfortunately, this doesn't pass, I think let's try to move in that direction. I know if I was a qualifying broker and I was trying to avoid coming in with my salesperson because they violated this, that would be my rule in my office.
Okay, good deal. Thank y'all so much. I do think it's a great idea. If we could just do away with Facebook, that'd be wonderful.
Yes, I agree. All right, the next thing we're going to talk about, I'm kind of going to move through this really pretty quickly because this is a long, briefly legal today, is regulating and dealing in equitable interest in contracts. And I touched on this earlier when I talked about the definition of owner, that we've actually included that in the law now. So basically, this just says that this bill requires any licensee, when selling an equitable interest in a contract, to purchase residential real estate. And again, this is only for residential, not commercial, residential, to disclose to the buyer that the seller does not hold title to the property. And again, because we've defined the word owner, whenever you're selling an equitable interest from this point forward, you would have to have a license to do this because you're not falling under that owner exception. So that is a new part of the law as well. And then finally, I'm going to look at RECAD. This is an area that I'm not going to talk a lot about because RECAD can get very technical. It's a lot to dig into on RECAD. Please go look at this part of the law on your own and come back to us with any issues. Just some highlights on this. And I do want to say that we had a very sage task force. They came in with so much wisdom, so many years in the business, and there had been so many calls by you all, the licensees, to change RECAD. They worked really hard on this. And some of the things that they did was they amended some of the definitions. They've been changed. Sub-agency has been removed from RECAD. Limited consensual dual agency has been removed. There's now a designated single agent, and that definition is in there. It's basically if two people work for the same company and one has a buyer and one has a seller, they can enter into this designated single agent. Those are just some of the highlights that are in RECAD. And I know that I know for years you guys have been asking for this, so we're real excited to include it in this legislation. So that's kind of the end of the legislation portion of it. Our goal is that you are here listening to us, and if you just look at the law, look at the synopsis. If you are a qualifying broker, it would be great if you guys met with your team, your salespersons, went over this with them. The more feedback we get, the better. And then again, as we stated earlier, any questions or concerns, please, you can email them to Serena. I think she gave her, have you given your email address?
If I have it, it's Serena, SERENA.Cronier, CRONIER @arec.alabama spelled out .gov.
Thank you. She's our point person, basically on the questions coming into the commission for this. So just send them to her. Any other questions before I move on to the next topic quickly on legislation? Okay, seeing none.
Is transaction broker eliminated or is it still in place?
Yeah, is this Mr. Casey?
Yeah.
Okay, yes, Mr. Casey. We have actually the word, and this was by the recommendation of the task force, the word has actually been changed to transaction facilitator. However, in the law, we have definitely made a point, and when you look at RECAD, you can see that legally the words transaction broker and transaction facilitator are synonymous. But we now will use, if this legislation passes, we will use the word transaction facilitator, but legally it means the same thing as a transaction broker.
Thank you.
You're welcome. All right. One thing I just want to do in this, I'm going to go through this pretty quickly, but it was something that we felt was important. And so that's why I wanted to talk about it today, is I wanted to clarify the process of how the legal division accepts complaints and how we determine to go forward on complaints. In the past, we've been a little bit more relaxed about how we did this. If someone sent in an email, because the law requires that any complaint be in writing. So if someone sent an email saying, laying out the facts, I'm complaining about this person, then we would just take that as the written complaint. Recently, we have changed to require that if you are a consumer or a licensee and you're complaining against another licensee, that you actually fill out a complaint form. Those forms can be found in 2 places on our website. The first one is under the consumer tab for consumers. It's a consumer tool, and then they can fill it out from there. And then also under forms, if you're a licensee, you can go to either place. It's also found in the forms, so you can do that. And the reason we're doing this for 2 reasons. One is just the statistical records we have to keep now due to an executive order of the governor. It's an easier way to do it if we have the actual complaint form. And it's also just to make certain that we're certain that what you sent in, you want us to look at as a complaint. It does not mean it's going to result in a formal complaint. It simply means that it's now, we have it. Serena is actually, she works as our triage person for complaints. So she reviews it. And then if she thinks there's a basis to it, such as, we definitely have jurisdiction, there could be, when it's looked into, it could result in probable cause for a formal complaint. She then forwards that to the investigative committee. The reason I want to touch on this is I just want you all to know, and I go around the state preaching this, so this is very important to me, that we want you to ask us questions. I would rather answer a question all day than to have anyone go in front of the commissioners, okay? I mean, I understand that's serious. I understand there's a license. Serena and I have a license that support our families. I understand the importance of keeping that license. So we don't take anything frivolously. So I just want to make certain if you have a question, I still want you to be comfortable coming to the commission, sending us a web inquiry, sending us an email, anything like that. If you want to send something and you just want to make certain we know it's a question and not a complaint, send it and just make sure you write at the top, this is not a complaint. I just am asking what would the commission do in this certain situation. So I just don't want you all to stop asking us questions, because I think that we've really developed a process for that over the last few years, at least since I've been here, that we are here. We're not big bad legal. We are your friend. We want to help you. We want to guide you. And I would be happy if I had no one on the agenda on a commission date. So please keep sending those questions to us because we do want to help. And again, if you want to feel better about it, put big letters. This is not a complaint. And again, we really are insisting upon a complaint being on a complaint form. I do want to say that when you send advertising in, and I'm just going to touch on this briefly because we've talked about it and we are handling it different. So I like to get the word out. So I'm not just pivoting from what I said I used to do. I got a lot of complaints that I was not taking advertising violations seriously enough because I was not bringing them before the commission. So there was no reason for people to stop advertising in the wrong way. So I've changed that. So now, and I want you to know, if you send it in as a complaint, we will be moving forward on the case. It does not mean they're going to go in front of the commission. We look at that complaint. Let's say you send me a Facebook post and it doesn't have the brokerage name. We go look, the investigators go to that person's Facebook. If it's a one-off, meaning every other thing they've done on Instagram, YouTube, Facebook is perfect, we'll make a call to the broker and say, hey, this one post is not right. I mean, everyone makes mistakes. We all get a mulligan. If I look at the Facebook, or the investigator looks at the Facebook, and every post for the last 2 years doesn't include the brokerage, then we have an issue. Then it's going to turn into a formal complaint. And we are bringing qualifying brokers in on these. So qualifying brokers, please make certain, at least once a month. Now, if it's a one-off, there's no way I'm bringing in a qualifying broker to the commission. But if you're friends with this person on Facebook and every post they've done for 2 years is wrong, you should have maybe looked at the Facebook. So anyway, that's how we're handling the advertising complaints. And again, please still contact us with questions and concerns. That's why we're here. And I hope this has been informative. I know it's been a lot of information thrown at you, but I just thank you for joining us. And please remember that you can always reach out to us. Our phone number is 334-242-5544. Our email is arec@arec.alabama.gov. Our website again is arec.alabama.gov. And we are all over social media. Our handle, I think that's what you call it at social media, is at AREC Alabama Gov. We are on Facebook, X, Instagram, YouTube. YouTube has a lot of good videos that our CPR department does. They have a lot of good information, and it might answer some questions you have. And most importantly, happy holidays, because I will not see you back for Briefly Legal until 2024. So I hope y'all have a great holiday season, a happy new year, and we will see you next year. Thank you.